I'm Randy Barnett from the Georgetown University Law Center. I was the lawyer for Angel Rach and Diane Monson in the medical marijuana case that came out of California and that was argued in the Supreme Court in 2004. I argued that case. It was decided in 2005. And one of the reasons why that relates to this case is because we had a Commerce Clause challenge that went to the Supreme Court. So I became quite familiar with both the Commerce Clause in the Constitution and the Supreme Court's ruling on the Commerce Clause. And the case, Gonzalez versus Raich, which is the case that came out of, the decision that came out of my case, is the case that's relied upon probably most extensively by supporters of the health insurance mandate. Well, first of all, if Congress is exceeding its Commerce Clause power, then it is intruding into the reserved power of the states, because Congress is limited under the 10th Amendment to the powers that are given to it under the Constitution, and all other powers are reserved to the states. So if Congress has exceeded its enumerated powers, then it is by that act alone intruding into the sovereignty of the states. But this bill does more than that. It also compels the states to do all kinds of things, including setting up insurance exchanges. It changes the scope of their Medicaid coverage. It does quite a number of things at great cost to the states. Now the question is, does Congress have the power to do that? Well, normally these sorts of things are allowed. It's not that Congress is ordering the states to do these things, at least the way the bill is structured, not as a command or mandate to the states, but saying that that the expenditure of Medicaid funds that the federal government gives the states is conditioned on the states doing all of these things. And if the states don't want to do them, all they have to do is give up their Medicare funding. But Medicare funding represents a tremendous portion of state budgets. It's tens of millions of dollars for every state. And in the past, when the court has approved conditions on spending being imposed on the states, and the last big court case involved a condition on highway funds that required states, if they wanted to get their highway funds, to raise the drinking age to 21. When that happened, only 5% of highway fund expenditures were made conditioned on the states doing this. And under those circumstances, the Supreme Court stressed that they did not think that this was coercive, because only 5% of highway funds were being made conditional on the states doing this thing. So here, in this bill, 100% of Medicaid funding is being made conditional on the states engaged in all this activity at great cost to the states. And that's something that the court may find is both coercive and thereby constituting a commandeering of the state by requiring the state to do all kinds of things, including enact legislation to implement Congress's mandates. I think that once this legislation becomes better known, and certainly once it goes into effect, there's going to be all kinds of challenges based on due process and liberty rights, and in particular privacy rights, as well as the privacy right to consult a doctor and be treated by a doctor of your choice without having a government interfere. The very same rights that have been protected in the abortion context are going to be applied over into the health insurance context as well. But these are not happening yet, and I don't expect that they're going to happen for a while. But I do think you're going to see challenges of other sorts. These would not be the sort of challenges, for example, that the attorney generals themselves would bring, because they wouldn't directly involve federalism issues. They would be more involved with personal individual liberty questions. But I think that your viewers should ask themselves all the reasons why they might be concerned about the right of privacy when it comes to a woman making decisions with respect to her reproductive choices, and ask themselves whether they think that that's going to be the only kind of medical decision that individuals are going to be privileged to make free of governmental interference or an undue burden being placed upon them. And if they think that that liberty will extend to other decisions besides abortion, then they can appreciate what future constitutional challenges may be made to this bill. Look, the smart money is always that the Supreme Court will uphold Congress. One of the reasons why Congress claims all the power it does under the Constitution is because for 60 years the court has by and large upheld Congress's claims to use its Commerce Clause power, use its spending power, use its taxation power in all kinds of ways that are not actually justified by the written Constitution, and which the supporters of this bill are counting on. And in fact, it would be the safe money that this bill will be upheld by the Supreme Court, including the conservatives on the court. However, if this bill continues to be quite unpopular, and if, for example, one or both branches of government of the Congress flips parties as a result, and if, for example, there's a strong repeal movement that might be blocked by a presidential veto or by a filibuster in the Senate, if any of those things happen, I think you may find that members of the Supreme Court might be a little more willing to consider serious constitutional challenges to the bill than they would be if the bill were considered to be very, very popular, like Social Security or Medicare is popular. So to the extent one wants to predict what the Supreme Court will do, and to the extent that is premised on the Supreme Court's impression of what's popular and not, some of the prediction is going to turn on how unpopular this bill is when the case finally does get to the Supreme Court, and what political changes have happened between now and then. And that's something that is very difficult to predict.